Good morning. Well, my name is Moses Cairo, and I have the honor or privilege of serving as the Dean for the School of Agricultural and Natural Sciences at the University of Maryland Eastern Shore. I'm delighted to welcome you all to this 10th Annual Agricultural and Environmental Law Conference. I think it's truly remarkable that this is the 10th installment of this annual conference. We are very pleased to be able to gather here with all of you being stakeholders in agriculture. This conference itself has proven to be quite unique because it brings together a broad range of stakeholders to really engage in a purposeful dialogue about supporting profitable and sustainable farming in a time when regulations are constantly changing and key stakeholders need to continuously adapt to all these changes. The agricultural law education itself has truly matured. I recall that during its infancy, nearly 12 years ago, a critical guiding principle was to listen and be guided by stakeholders and their needs. This conference, in a sense, continues that ethos because on the one hand, in addition to sharing knowledge, the other part is also to get feedback from you in terms of what your needs are and what challenges that you're facing. So this year's conference brings together another very full and purposeful agenda. We are happy to have speakers from Maryland, Baltimore, University of Maryland, Baltimore, Francis King Curry School of Law, West Virginia University School of Law, the Ohio State University, the Maryland Food Bank, Fast Fruit Farm, as well as county and state agency leaders and leaders in law and advocacy, and of course our Maryland Extension team. This broad team of speakers will share with us their unique perspectives and insight into topics from developments in right to farm laws, food donation laws, and the future of regulating value-added agriculture to Maryland's new regulations for using food processing residuals, and of course developments in solar energy in Maryland. As always, we really do urge you to engage with the speakers and get the most out of the different panels. Please ask as many questions as you can. Clearly, as Marylanders, we need to work together to keep Maryland being a leader in agricultural production and agricultural enterprises, and really providing leadership in a number of areas, including this particular area that we are discussing at this conference. For us at the University of Maryland Eastern Shore School of Agricultural and Natural Sciences and UMES Extension, we remain very focused on the idea of working with you as stakeholders, with our students, developing the workforce of tomorrow, and providing enhanced knowledge and technology to improve the viability of agriculture in the broad context. We are really committed to serving all the communities and citizens of Maryland in this regard. But I'm delighted that over the last decade, this very unique initiative that brings together the three universities, the University of Maryland College Park, the University of Maryland Baltimore Curry King School of Law, and University of Maryland Eastern Shore, all of which invest people and resources to really ensure that this initiative continues moving forward in a positive way and providing research and knowledge that hopefully makes a difference to the agricultural enterprises in the state. This team remains strongly committed on this mission of supporting agriculture, and we truly hope that you'll find this conference another opportunity to benefit and increase your understanding of some of the issues that are facing the agricultural community from a context of agricultural law and environmental law. So with that, I do hope that you enjoy the conference today. And with that said, I will call on the next panelist. You know, it's interesting, I was looking at a picture up there, my picture, and that picture was nearly 12 years old. It's sort of anyway, thank you very much.
Good morning, everybody. And I'm going to call up our first set of panelists, and I'll read a little bit of their bios as they come up to the stage. We're going to have a discussion on the right to farm statute in Maryland and across the U.S. We have Professor Jesse Richardson, Jr. He is the Hal J. and Roscoe P. Poston Professor of Law and the lead land use attorney at the Land Use and Sustainable Development Law Clinic at West Virginia University College of Law. I should not try to read fast early this morning. And then our final panelist, which I will bring up real quick, is Tony Gorski. Tony specializes in environmental, natural resources, and agricultural law. In addition to providing advice on permitting and compliance, he represents clients in trial and appellate litigation in the state and federal courts and administrative forms. So I will turn it over to these two gentlemen to get started. I forgot the order we picked, but I believe it was Jesse first. And then I will walk down to take help with questions later.
Good morning. Thanks for inviting me here today. I'm going to kind of give an overview of Right to Farm and a little history about Right to Farm. I get to teach Right to Farm a lot in my land use law class, and I don't know how many people know this, but Right to Farm started with a 1972 Arizona Supreme Court case in Spur versus Del Webb. Del Webb was a developer that still exists, actually. And instead of building right outside of Phoenix, he leapfrogged out into Sun City, Arizona, out in the country. And my guess is that there was one owner of a cattle feedlot that wouldn't sell to him, Spur. But Del Webb went ahead and built his housing development anyway. And then after people started to buy lots and build their houses, all of a sudden they discovered that feedlots stink. I guess the wind was blowing a different way when they came to look at the lot, I don't know. And so Del Webb and some of the purchasers of the lots filed a nuisance lawsuit against Spur, the owner of the cattle feedlot. And the judge came up with a very interesting solution. So first, the judge found that the feedlot was a nuisance. And part of that was the odors, there was manure, and the manure attracted flies, so it was a nuisance. But then when the court fashioned a remedy, the court said that Del Webb was partially at fault for coming to the nuisance. So the court said, Spur has to move, but Del Webb, you have to pay for Spur to move. Think about that for a minute. Who won that lawsuit? Del Webb, because he was trying to buy Spur out anyway. So the court kind of forced Spur out. Well, all 50 states the legislature said that's not fair. If the farmer is there first, somebody that comes to the nuisance, and from the lawyers in the room, you've heard of coming to the nuisance, but it's really not a defense, it's just a factor. Well, all 50 states passed right to farm laws that made it a defense and said if the farmer is there first and the farmer complies with generally accepted agricultural practices, then it's an absolute defense to a nuisance suit by somebody who comes in later that the farmer was there first. And most of the states passed those laws between 1978 and 1983. In the intervening decades, some states, like Iowa, and I believe Ohio, Peggy, also exempted agriculture from zoning. Does Ohio do that? Yeah. So some states said, we're going to protect agriculture from the evils of zoning and the local government. And some states said, we're going to exempt agriculture from the building code. The next really significant developments in right to farm, though, didn't come till 1998, when Iowa and Washington State, the Supreme Courts of both states, found that the right to farm statute was a regulatory taking. And the theory of that was that basically the state, by passing that law, was forcing the neighbors to have an easement across their property for odors and noise and dust and that type of thing. So in the parlance of regulatory takings, that is a physical invasion and a categorical taking. So, you know, in the late 1990s, early 2000s, it's like, whoa, right to farm might go away. And there were some brilliant law review articles written during that time. I recommend one by this guy from WVU. And we all predicted that, wow, you know, right to farm is going to have to change. But it didn't. The Iowa Supreme Court started backing off. But before they backed off, they said, in 2004, they said not only does it violate takings, but it violates the inalienable rights clause of the Iowa Constitution. That means that people can not only get the value of the reduction in their land, but they could get damages for personal injury and that type of thing. But in 2022, the Iowa Supreme Court totally backed off on that. They overruled the inalienable rights clause case, which means that now in Iowa you can just get the reduction in the value of your land. And they also really kind of backed off from the Borman case that said it was a regulatory taking. I found this to be really, really strange, because also in 2022, the United States Supreme Court ruled on a case, Cedar Point, and said that when California passed a law that said that farmers have to allow labor union representatives on their property to talk to migrant farm workers, that is a physical invasion and a regulatory taking. So the United States Supreme Court adopted Iowa's reasoning, and Iowa said, no thanks, we're backing off. Now before, and I'm not going exactly in order here, But the most recent really huge change in right to farm came from a 2020 North Carolina case that was in the Fourth Circuit Court of Appeals, Murphy Brown. In that case, we had some intensive hog operations, CAFOs, concentrated animal feeding operations. And CAFOs have been a really big point of contention with right to farm too. Over the decades, courts have kind of struggled with, is a CAFO a farm? Should it get protections of right to farm? Some courts kind of lean toward no. So the state legislature stepped in and said, oh yeah, CAFOs are farms and they get protected too. But in 2020, the federal court found that landowners in North Carolina were entitled to $75,000 in compensatory damages and $5 million in punitive damages because of hog CAFOs. Well, that spurred this new generation of right to farm acts. And the changes to the Right to Farm Act came in several different ways. Number one, a lot of states changed their right to farm to say you don't have standing to sue unless you live within a half a mile of the farm. So if you're further than a half a mile, you can't even file a lawsuit. Number two, to have standing, you have to own the land or be a majority owner. Next, that immunity from local regulation got expanded. Not only is zoning bad, not only are building codes bad, but anything that the local government does is bad. And farmers shouldn't have to listen to that. And in response to Murphy Brown, the state legislature started placing limits on the damages that plaintiffs could get against farmers in nuisance suit. No punitive damages. And some states said your damages are limited to the reduction in value of your land. Other states also started to broaden the definition of agriculture. We're going to talk about agritourism next. In a lot of states, agritourism is now agriculture protected by right to farm. And agritourism is defined very broadly. Agriculture defined very broadly. And probably one of the biggest things that states expanded on was attorney's fees. If you sue a farmer for nuisance and you lose, you have to pay the farmer's attorney's fees. That's a little bit of a deterrent because it could cost you tens of thousands or hundreds of thousands of dollars. Now, West Virginia, and don't ask me why, because we've never had any right to farm problems in the state. But they heard about Murphy Brown. And so West Virginia has the most stringent right to farm act in the United States. I call it right to farm on steroids. They have everything. Everything that I talked about, they have. The most troubling thing was passed in the last legislative session that said that agriculture is exempt from all local regulation. We are concerned, among other things, that means that local governments cannot enforce their floodplain regulation. That means local governments cannot participate in the National Flood Insurance Program. That means that the flood insurance of everybody in West Virginia will skyrocket in price. No more federal subsidies. All 55 counties in West Virginia are in the floodplain. So lots of uncertainty. And I'll mention one other thing before I turn it over. Like I said, West Virginia, for whatever reason, seems to be in the bullseye of this. And the West Virginia Farm Bureau and the West Virginia Department of Agriculture are defining agriculture very broadly. Basically, their position is USDA defines a farm as a parcel of land that produces at least $1,000 in agricultural products. You don't have to sell it, you just have to produce it. The West Virginia statute goes a step further and says any parcel of land capable of producing $1,000 in farm products. That's about every parcel of land in the unincorporated portions of West Virginia. No local regulation. There was a proposed plant in Hardy County, West Virginia. They have zoning. It was a fumigation facility to treat logs with methyl bromide so that we can ship them to China. Hardy County said prohibit it by zoning. The battle was set up. They said methyl bromide is a pesticide. Lumber comes from trees. That's agriculture. We're protected by right to farm. Luckily, I shouldn't say this, I don't want to be biased. We avoided that battle because that business decided not to locate in Hardy County. But we are set up for a battle in West Virginia. Like I said, if you produce $1,000 worth of ag products, the position of the state is I can have agritourism that produces $500,000. I can do whatever I want because I'm a farm. And I know there's been some recent developments in Maryland, so I'll turn it over to Tony to talk about that.
Thank you, sir. Is this working? Yes, okay. Maryland hasn't gone as far, obviously, as West Virginia has. And Maryland, however, started doing right to farm legislation back in 1981. The most recent change, I think, was not 1998. And that's interesting for us now because, as many of you know, we have a lawsuit that came out of Talbot County, neighbors suing a farmer over the use of DAF as a biological additive for their fields and the alleged nuisance that came from that. The way Maryland is structured is that there is a state law on right to farm, and what it requires is that if the agricultural operation has been in business for more than a year, then it is immune to tort lawsuits, nuisance lawsuits from neighbors for odors, noises, smells, dust, that kind of thing. And so in Maryland, that's what the state law says, and the state law encourages every county to adopt its own version of the same thing. And it allows some flexibility, and it asks or encourages those counties to set up their own, what we refer to as like an agricultural review board. And so in Talbot County, the neighbors had filed a complaint with the agricultural review board. That's how the The lawsuit that's currently on appeal is started pending, or began. So what happens in Maryland is if you have a complaint, if your county has a review board, then you're required to file, and you have a complaint about a farm for odors of some kind of nuisance, you have to file with your local review board under the county code. And that review board will then review the activity, and I'll talk about what they're looking at in just a second. But the key is in Maryland, the protection from liability for farmers is applied at that point. You're not allowed to go to court unless you've gone through either the local board, and if your county doesn't have a complaint or a local review board, then you have to go through the Maryland Department of Agriculture's mediation process. So there's a default. If the county doesn't pick up and do something and have a board, then the complaints are supposed to go to the Maryland Department of Agriculture and put through their mediation process. Some of you may be familiar with that. I don't know, they've had that mediation process for quite a few years now. I've had a couple clients go through it. It's a pretty good process. You get a mediator who's usually in your community, and they sit down with the farmer and the neighbor and figure out how to address their issues. It usually works pretty well. But anyway, so those are the two options. Now, if your county has a board, then the complaint of the neighbor goes to the review board. And the review board's job is to decide whether or not to decide whether or not there's a nuisance. That's a court issue. The review board's job is to decide whether or not what the farmer, A, is it a farm operation or an agricultural operation under the code? And B, if it is an agricultural operation, has it been in use for more than a year? And then whether or not its activities are what you refer to as generally accepted agricultural practices. And so the question that came up in Talbot County was whether or not the change from the use of commercial fertilizers to using DAF was a generally accepted agricultural practice. And what the local court decided was that it decided that the change was an operation in and of itself. So switching from commercial fertilizer to DAF was a new operation, was how the circuit court looked at it in Talbot County, and said that it was a new operation. The complaints were filed less than a year after it began operating, and so the farmer had no protection. All right, so that was appealed, and that went up to the Appellate Court of Maryland, which is the middle level. It's in the Maryland trial system. You have, if you go through a trial, you have one appeal, what we call appeal of right. You have a right to appeal, and it goes to that medium court. You don't have a right to take it up higher. You have to ask permission to take it up higher. So what happened in this case, they filed with the appellate court. The appellate court looked at it and looked at the code, the state's code, as well as the county code, and viewed them as pretty much, the county pretty much adopts and follows what the state has in its law. And again, agriculture is defined pretty broadly. Maryland defines agritourism very broadly as well. But so when you look at what the circuit court did, the circuit court's decision, remember, was that the change from commercial fertilizer to use of DAF to apply on the fields was, they were storing DAF as well. They had a storage facility constructed, bunkers, I think, and so they had DAF storage there too. And so the neighbor's complaint was not only the use of it was causing odors and flies, but that the change was also this now storage. Now the farmer was using, based on the record, the farmer was using the DAF that he stored on his own farms, just other locations, as well as the location at that one point. And so what the local court decided was that whole change to DAF and to storage was an operation, an agricultural operation, and that was new. So get to the appellate court, and the appellate court looked at it and went back through what Maryland had done beginning in 1981 all the way up to today. And what the legislature adopted in 1981 said that an agricultural operation and any changes to it had to be ongoing for a year. Well, in 1998, the Maryland General Assembly, there was a proposal to remove the 1-year requirement from the statute altogether, so that once you establish your ag practice or your agricultural operation, you were good to go. You were protected from tort liability. And that didn't pass, but what did pass was to get rid of the 1 year, get rid of the language discussing changes. So the statute from in 1998 forward became one where if an agricultural operation was in place for more than a year, it was protected from lawsuit, protected from tort immunity from neighbors or tort lawsuits from neighbors. And so the difference being that if you have a farm, in the old statute, if you had a farm and you made some change, whatever that might mean, then that change was subject to a 1-year limitation period before, once it was in effect for a year, then you gained the immunity as the farmer. So by taking out the change part, Maryland's law now says, as of 1998 forward, so it's been that way for a while, Maryland's law says that if the agricultural operation is there more than a year, and as long as they're operating in compliance with the law and using generally accepted agricultural practices, then they're not going to be, no one's going to be able to, the neighbor's not going to be able to sue them in the courts for a nuisance. So then what happened in Talbot County was the argument about the change, and what the appellate court said was, no, Maryland used to say that the change had to be in place for a year before you had protection as a farmer, but it was changed in 1998, so it doesn't say that anymore. It now says just the agricultural operation has to be in place for a year. So you're looking at this definition, what is an agricultural operation, and is there something about this particular operation in Talbot County at the farm that made it so that the agricultural operation itself was something that was different or was new, and the appellate court said no, that was an incorrect interpretation of the code, that based on the record, this change in practice from commercial fertilizer to application of DAF or biosolids was not an agricultural operation, it was a practice within the agricultural operation. And so what the court talks about is the idea that if someone has cows and they want to switch to poultry, or if someone is growing grains and they want to raise poultry, that those are the kinds of things that a farmer should be allowed to do to make their farm sustainable. And so changes in how the farmer goes about conducting its agricultural operation are just practices within the operation. And if you think of it in that sense, it's, in some ways you can think of, obviously anyone can think of pretty extreme situations where there are changes that are made, but one of the examples is if you use commercial fertilizer on your farm and then you want to build a tank for a large supply of commercial fertilizer for your farm and your family to utilize, that would not be something that is a new operation. And so, because that's a practice within the farm operation or the agriculture operation, and so the question then becomes, is it a generally accepted practice? And I imagine there's a point in time where one of the things that the neighbors were arguing in the Talbot County case was that there was the operation was the storage and distribution of DAF, not the application of the fertilizer or the DAF instead of the fertilizer. And the court looked at that basically as, the Agricultural Review Board determined that that was a generally accepted practice, that if you utilize DAF, you may have a storage facility at your location. And just because it's not all being used on that one property doesn't mean it's not part of your agricultural operation. And so you're allowed to do that. So, and in Maryland, what happens is when the local review board takes a look at a complaint, and they go through and they hold a hearing and they listen to all the witnesses and they make decisions, they make factual findings and say, here's what we believe, and this is or is not a generally accepted agricultural practice. The appeal route from that is to ask a local court to review their decision. It's called a petition for judicial review. And that review is not a new trial, and it's really not supposed to at all look at the evidence and the facts. It's supposed to look at what the board decided and then look at what the board's record. So the test when you go up on appeal, the test is, was there enough evidence in front of the board to support their decision? And we call it the substantial evidence test. And the substantial evidence test is, the court, and this is the idea is that the people who hear the witnesses, which is the board, the local board, as they sit and hear the witnesses and look at pictures and go through the testimony and all of that, they're arbiters of the facts. They are the ones seeing, who's credible, who's not a credible witness, and this is a typical appellate review process for factual decisions. Most appellate courts don't look at the facts that a judge decided. They only look at the facts a judge decided to see if there's enough evidence to support those facts, not whether or not they think the judge is right. And that's how the appellate courts look at these commissions, the local board decisions. Is there enough evidence, whether it's photographs, whether it's testimony, whatever it is there enough evidence in front of the board to support their decision that it is a generally accepted agricultural practice? And so an appellate court and the circuit court should have looked at the board's record to say, all right, here's what the board said, it is generally accepted, and they wrote reasons as to why they thought it was. And so are those reasons in evidence? Is there a document, is there a witness testimony, are there photographs that support what the board found? Okay, so the circuit court is not supposed to look at let's say there's three or four people testifying for the farmer, 3 or 4 people testifying for the neighbors. The circuit court, when it reviews that decision, isn't supposed to look at what each of them said and decide what evidence they think should control. In other words, I believe the neighbors or I believe the farmer. The circuit court is supposed to look and say, is there enough evidence that supports what the board decided? And in this case, that it was a generally accepted agricultural practice to have DAF stored on the farm. And so, and the other aspect of what the court disagreed with, or what the appellate court, I'm sorry, keep saying court, what the appellate court decided in overturning the circuit court's view of that case in Talbot County, the appellate court said, number one, the statute doesn't say that the change has to be in place for a year, only the operation. And number two, the court looked at it and said, what you're supposed to look at is whether or not there's substantial evidence, not whether or not the judge or the appellate court would agree with the decision. It's not about whether the local board, and this is an odd phrase, but it's not about whether the local board is correct. It's about whether or not there's enough evidence to support the local board. And that's a weird phrase for most people, but not for lawyers. And so the real issue is, think of it this way. You may, if you were to consider investing for your future and you had 4 different proposals in front of you, one of which was snake oil, and you knew you weren't going to do that. The other 3 were reasonable, but there was something about one of them that made you think, I like that one better, I'm going to go with that one. Well, that's what a reasonable mind would do. A reasonable mind would look at all the things in front of it, ignore the ones that are crazy, wrong way to say it, but ignore the ones that aren't well supported and go with the ones that are supported. That's what the court is doing when it's reviewing these board decisions, or when it's looking down at what a circuit court does. It's looking at the 4 options I spelled out for your future investment are the record for the agency decision. It looks at all the evidence, all the testimony, and are there things in the evidence and the testimony, whether it's a transcript or documents, is there something there that says that the board relied on and that is factual and is correct? And as long as it's in the record and the board has something that it's pointing to and saying, here's the part of the record that we believe shows that this is an accepted, generally accepted agricultural practice, the court's not supposed to consider what other people said about it. Because if you think about it, the judge in the circuit court case reviewing the board, they're not sitting in front of those witnesses and listening to what they say and hearing what they have to say. They're looking at a transcript. You're reading what someone said, just a written version of what was said, or you're looking at their documents, you're looking at their photographs. The courts in the United States have always said that the trier of fact has to see the witnesses, has to see the evidence, has to see the case presented. And so if you don't have that opportunity, you don't understand why the board thought this piece of evidence meant more than that piece of evidence. You have to be there. And if you think about it, it makes sense in everyday life. When you make decisions, you don't like to make decisions unless you get the information yourself, or you have some indication that this information is going to be accurate. You're not, and that's the other part of what the court had problems with. Now, the appellate court decision overturned what the circuit court said. It agreed with the local board and said this is an agricultural practice within an agricultural operation. And so they had protection. The operation had been in, the property had been a farm use for generations. And so that was the other thing, of course. The question, it became a bit of a discussion about if you sell your farm, does the buyer have to start over again? Does the 1 year have to start to run again? So whoever buys your farm operation is in jeopardy for tort lawsuits for a year until they've established their own agricultural operation, and that's not how it works. It runs with the use. So if you have an ongoing agricultural operation and you pass away and your children inherit it, they inherit that protection from tort liability as well. If you sell it to someone else, they do too, as long as they don't stop operating. If they stop operating and then 3 years later come back and want to set up a hog farm, it's not going to work the same way. So if there's a pause, and this is similar to a lot of zoning situations, if there's a pause in your business that stops it, when you restart, you don't necessarily have those same protections anymore. But it's not based on the sale of the farm or inheritance of the farm or change in ownership of the farm. It's just about the continuation of the operation. It's not the think of it this way, it's not the operator, it's the operation. So things can move forward and go. How are we on time, Paul? I know we were going to do some Q&A, and I'm...
8 minutes left for Q&A.
Okay. If anybody has any questions, I'd be happy to address them. Someone in the back?
There's a microphone coming, but I'll just project if that's okay.
I can hear you.
I appreciate all that information and background. Martin Crew, Maryland Department of Agriculture. Questions directed to Tony. I definitely welcome Justin's perspective on this. And it's about thresholds as it relates to right to farm and what's protected. Obviously, the assumption would be that an agricultural operation is compliant with all Maryland state laws. One of those state laws is a nutrient management plan after a pretty low threshold, $2,500 in revenue or $8,000 or 8,000 pounds in livestock weight. I guess my question is, especially when you're talking about these local ag reconciliation boards that may or may not exist, is there any mechanism to clarify that? And I guess the underlying question is, do you need a nutrient management plan to be protected under the right to farm, or the backyard flocks and a few horses in the backyard also falling under this?
The best way to think about it is if there's an obligation, if there's a legal obligation to have a plan or to have a stapler at your desk, whatever it is, if there's a legal obligation to have something as part of that you're required to have in order to have a legal operation, then that's a requirement. You have to be operating in accordance with the law. Generally, that's thought of as the big picture kind of things. So, for example, if someone filed their renewal of their CNMP or their NMP, their annual renewal for whatever general permit they might be covered under, if they filed their renewal late, I don't think that the court would say that that's a lapse that resets the 1 year. And if you think about it, you could have these permits only run for a certain, some of them are annually renewable, some of them are 5-year permits. It all depends on what you're looking at. But the last thing that the state wants to do, I think anyway, is to have someone build their, let's say, a dairy operation. You get everything in place, you get your CNMP, you have all your permits, and you go, and you spend $1.5 million setting up a milking parlor and do everything else that you need to have for a dairy operation, and then you file an application, a renewal late next year, and your $1.5 million investment is lost, because now you are subject to tort liability, and I'm pretty sure it's not going to work that way. There's not been any case like that, but I would expect that for minor violations, like if you had a violation of your NMP, I don't believe that would reset the 1 year, or that someone would be able to say, you had an NMP, but you renewed it too late, or you had a violation that the state has come in now and cited you for, and so when you got cited for that violation, your liability protection was gone. I don't think that would be the case. Other questions?
Where do I need to run to next?
No, nobody.
I believe you addressed this, but just to clarify, so agritourism is included in the right to farm for Maryland. Is that correct?
Yeah, agriculture operation, agriculture is defined to be this wide set of things, and one of them is agritourism.
What about animal-assisted therapy?
To the extent that having the animals on your property constitutes an agricultural operation, and I think it does, then you would be covered.
Morning. I sit on a board in Harford County where we are struggling with ag accessory uses. And what is the definition of agriculture, and what is its definition of an actual permitted accessory use under ag zoning? And so this is very interesting in the context of right to farm. But it is a question, agritourism, is that a permitted ag use? Is it an agricultural use?
Unfortunately, in Maryland, the state law is very broad as for its definition of agritourism. It covers anything you can practically think of. Camping, for example, is in the state's definition of agritourism. But it's not a preemptive definition. In other words, that definition is the state's definition. It doesn't mean that every county has to follow that definition. The counties are allowed to adopt their own definitions in their zoning codes for agritourism. And many of them, some have followed the state's definition. Many of them have just picked things and put some things in, but not other things. And sometimes they say, et cetera, or as, the ending of the code will say similar activities, that kind of thing. And so it's a question as to what is. But each county is going to have a definition that it uses for agritourism, and that's, for your purposes on that board, you would be looking at just the county's definition.
And a follow-up other question on a different concept. When one has a niche, a small agricultural production on small parcels of land, and that parcel of land is in a community that has development regulations. This has come up in my area. Is there any right to farm protection if there is a recorded set of development regulations that restrict the numbers of animals or the types of animals on a piece of property?
You're looking at two things. You're looking at the idea of an agricultural operation and where it can be. And I think that an agricultural operation, I know some locations on the Eastern Shore that grow specialty peppers for Asian food markets in DC, and they don't need much space. And so, excuse me. So I think that can happen anywhere. But if you buy a piece of property, and the flip side of your question is contract law. So forget about ag and look at the contract. When you buy a piece of property that has deed restrictions on it, you're signing a contract that says you're going to stick to and abide by those deed restrictions. And it doesn't really matter whether you have a right to farm or not. You have contracted with all of your neighbors to comply with these restrictions, and those are the restrictions that will apply.
Thank you.
Okay. And I want to thank our panelists for coming today. And I guess Jesse gets to stay up for the next panel, but Tony's free to come downstairs.
And I empathize with you, because those boards are not easy to sit on and have those things, because a lot of that, for example, your question, I don't know that it's right for your board to make that decision, because it's a contract decision.
What's that? You guys have to share mics. You have to share mics. Wait, okay. Good morning, everyone. All right. I see a lot of familiar faces in the crowd, and I also see some new faces, so I'll go ahead and introduce myself. My name is Megan Todd. I am a senior legal specialist or research associate and managing director for ALEI programs at the University of Maryland, Baltimore School of Law. Been with ALEI for about five and a half years now, so thank you all for coming out. I will say I can't tell if I'm happier today from seeing all your faces, old and new, or if that we're finally done with the planning phase of this conference and we're actually here doing it. So either way, it's a really great feeling. Thank you so much for coming out and spending all or most of your day with us today. So a lot of you know the drill. We have 45 minutes to switch gears into another topic, so let's get into it. The next panel topic we have is planning for the future of value-added agriculture, a topic that's back again on its third year in a row by special request. It's a very hot topic for us. I know that at least 3 of us are awake this morning, so just by a quick show of hands, how many of you have at least heard of value-added agriculture? It literally should be everybody in this room. Everybody, okay. And how many of you feel like you could actually give a clear definition of what it is, though? Oh, okay, definitely Martin. I expect that of you. All right, well, this is the right panel. We have some highly esteemed professionals, 2 legal professors and a planner from Queen Anne's County, to give us all a really quick crash course in what is agritourism, what are the factors and strategies seen across the U.S. for regulating value-added agriculture, and also give us a little bit of insight into the implementation and how that plays out on the local level. I'm very excited to have this panel today. We have on the far side here Professor Peggy Kirk-Hall, who is the Director and Associate Professor of Agricultural and Resource Law Program at the Ohio State University. I have learned that we need the. We have Stephanie Jones in the middle, who is a long-range principal planner for Queen Anne's County Planning and Zoning Department. And you all are familiar with Professor Jesse Richardson here on the end, Professor of Law and the lead land use attorney with West Virginia University College of Law. So we have some presentations, and without further ado, I will hand it off to Jesse to tell us what is agritourism.
So I have up on the screen some definitions that come from the National Agricultural Law Center. The U.S. Department of Agriculture has referred to these also. A form of commercial enterprise that links ag production and/or processing with tourism. The purposes are usually listed as entertainment or education. And really, the intent is for an agricultural producer to be able to generate additional income. And if you look at land use parlance, and we just heard about accessory agricultural uses, agritourism should be an accessory use. The agricultural production is the dominant or principal use. The agritourism should be subordinate to that and linked to that somehow. If the agritourism is the principal use, that's a whole new ballgame. I'll I will say, however, when we say what is agritourism, like when we say agriculture, one answer is it's whatever the state legislature says it is. And in Maryland, the local government can change that in some circumstances. We cannot in West Virginia. It is what the state says it is. And I also suspect that in Maryland, if a local government tried to define agriculture so that it excluded some things that were defined as agriculture at the state level, I don't think that would fly either. So you have to basically listen to the state. So this is the last boring slide that I have. I'm really excited because my slide presentations usually suck. Because what does a lawyer put on a slide? Two people fighting each other? I don't know. But now I get to say, is this agriculture? It's a corn maze. Not only a corn maze, it's a Taylor Swift corn maze. What says agriculture like Taylor Swift? Pumpkin picking patch. Is that agritourism? Petting zoo. Is that agritourism? Now I get controversial. Wine tasting. Is that agritourism? Now I'm going to get really controversial. Kinda. Farm stays. Big deal in Ohio, right? Is that agritourism? I think next one's really controversial. No, not really, guys. Hay rides. That's agritourism, right? Here we go. Haunted house. Agritourism? Or is it only I went to a haunted house recently, it was brilliant. But instead of being scared, I was just like, is this agritourism? I was so focused on that, I didn't even notice all the scary stuff. Is it only agritourism if the zombies used to be farmers? I don't know. Concerts. Very popular. Is it Luke Bryan or who is it that's going around the country giving farm concerts? Hey, I know my music, don't I? But I'd rather have Taylor Swift do it. Is that agritourism? Big deal in West Virginia. All the farms have bouncy houses. I'm going to reveal my bias. I have no idea what connection bouncy houses have to agriculture. Some people say, what if it's shaped like a farm? I don't know. Baloney. All right, my favorite. When is a wedding agritourism? I jokingly said one time in a presentation, a goat has to be the ring bearer for it to be agritourism. Somebody came up to me afterwards and said, a goat was a ring bearer in my wedding. And apparently it's pretty common. How about if a goat is just a friend of the bride? Is that enough to make it agritourism? And I think the last one would have to be agritourism. What if two goats get married? This is actually an invitation to a wedding between two goats. I think that's agritourism. Weddings are a huge issue. Neighbors hate weddings. I'll turn it over. Oops, you don't need it.
How do you follow that? And I was sitting here thinking, in Ohio, or the Ohio, if you like to make fun of us for that, we have had all of those kinds of scenarios come up. And I'm the one, unfortunately, being the public, the free public attorney at Ohio State that gets these questions. And the answer is, well, where we are in Ohio, it depends how you define agriculturally related, because our definition of agritourism says it can be all these kinds of things: entertainment, recreation, cultural, historical, but it's agriculturally related. And so I was looking at each of your pictures, Jesse, trying to think through, okay, what is that relationship? And this is something that not only we in the legal profession, but many of our ag economists, our ag rural sociologists have been dealing with for quite a few years now, is just trying to understand what is this thing that we're calling agritourism, and how do we define it? And then eventually that really important question of what's in and what's out. And so I'm showing you here something that we use, or that we've pulled from a couple of those ag economists and sociologists, as they have tried to get some kind of structure around this issue of how do we define agritourism. And that's really important because many of the laws that we now have, of course, tie to agritourism, so we're backtracking and trying to decide, is this ag tourism, does this law apply to this activity? So you can see here, I know it's probably not as big as you would like, but you can find this easily online if you search for this conceptual framework for agritourism. You'll find these authors have been very successful at getting this out there and talking about this. How do we define this concept of ag tourism? And what this is doing, I know it looks rather busy, but what it's doing is trying to designate there are core activities in these certain areas that we keep coming back to and saying this is ag tourism. So those areas are education, direct sales, entertainment, outdoor recreation, hospitality. So within those different areas, we have our core activities, and then we have our more peripheral activities. And though they don't say it, I think these authors are trying to argue that we should regulate those differently. We should regulate core and peripheral a bit differently. And I think it goes back to the whole issue, Jesse, in zoning. What's the principal use, what's the accessory use, what's primary, what's incidental, and trying to put some framework around those ag tourism type activities and define them that way, and then decide which laws apply to them. But that's a very, very difficult, challenging process that many in my state, and I know you all here in Maryland have struggled with that as well. Just how do we first understand what we're dealing with when we're talking about ag tourism? And I think some of it goes back to, well, what's the original intent here? Why do we have these laws? And if you look historically in many states, the intent is to protect that industry. And so I've given here, whoops, I think I'm controlling it. I'm not controlling this screen. Who is, there it is, okay. I was controlling it on my computer. Never seen one like that. If we look historically at agritourism laws, and you'll see there at the bottom of the screen, I work a lot with the National Ag Law Center, and I've worked on their agritourism compilation that's available on their website, where we've put together and we try to keep updated all of the state agritourism statutes. And there's only a handful of states now that don't have what we would formally call an ag tourism statute. About 6 states, I think, that have not yet done that. But you can find all of them on our compilation on the National Ag Law Center's site. And just identifying the laws in and of itself is a challenge because there's different terminology used. But if you look at that body of law historically, a lot of them started out with this very clear intent, and that was to protect those producing farmers who wanted to diversify their farms and offer some types of additional activities because I find it interesting. A lot of people hate farmers, but at the same time, they want to go to farms, right? There's a little bit of a strange dynamic there, but people love to visit farms. And so if a farm that's producing either livestock, crops, any of those types of traditional goods that we produce, wants to bring people out and allow them to enjoy that, let's encourage that because that gives them another revenue stream. And so how do we encourage it? We encourage it by giving them liability protection. And that is really the heart. That's the beginning. That's where these ag tourism statutes started, with offering immunity, liability protection, assumption of risk type approach that, hey, please do come out to our farms, but if you do, you're going to assume some of the risk, and our farmer's not going to be liable if you trip and fall or you're harmed while you're out there visiting the farm. So that's where it began, liability protection. But over time, we see other types of purposes embedded within these laws as they've changed, as they've been revised or amended. And so we start to see some of them are really about marketing. If you look at Georgia, for instance, is there anyone here from Georgia? Their law is very marketing oriented, that we're going to try to help market these operations. And so a lot of their provisions will provide those marketing benefits. Then we get into the land use stuff that Jesse and I can talk for hours about. And I think nuisance is kind of thrown in there too. But now we're talking about nuisance protection, zoning protection. Ohio has, I think, probably the strongest zoning exemption in the country for agriculture, and agritourism is now included within that, where it's hands-off agriculture.
West Virginia will challenge that.
Yeah, but now that I'm hearing, right, what you're saying, in a little bit different way that you're going about it through West Virginia, yes. And by the way, I have to say, I received a text a couple of weeks ago about 11 o'clock at night from Jesse saying, do you think a haunted house is agritourism? He really was thinking about it. And I'm sad that ruined your experience, Jesse.
I still had fun.
Sometimes we can't take off our lawyer hats. So we go to land use codes and we start looking at certain exemptions for agritourism. And there aren't as many states that do that. Mine is one of them. And boy, does that cause consternation with neighbors and local land use regulators. We have some laws across the country that have looked at food licensing and tried to treat agritourism differently when it comes to those food licensing requirements and give some exemptions, some different processes there. And then finally, I want to talk about property tax treatment, because this one has been the latecomer to this whole ag tourism discussion. A lot of what we've talked about over the years has been, as I said, liability and land use. But more recently, some of those same local governments are looking at these ag tourism operations in my state, and I think you're seeing that here as well, and saying, wait a minute, why are we treating this differently when it comes to property taxes? And all states have differential property tax assessment laws that say we are going to treat agriculture favorably when it comes to property taxation. We're going to reduce, basically, those property taxes that agriculture pays because it's different. And we're going to base those taxes in just about every state. The basis is we're going to base that on the ability of the land to produce and tax according to that. And we're not going to tax it under just, fair use, market use, that kind of valuation. So totally different taxation. In my state, if you have ag land, you're paying about 30 to 40% of what you would pay if it were taxed as commercial land or other types. So it's a significant tax savings to have that property tax treatment. But what about agritourism? Should it receive that same treatment? And that's where many of our folks, I did it again. Thank you. That's where many of our folks are starting to question that definition of agritourism and whether these special treatment laws should apply in regards to property taxes. And I hope you can see this, but there are 7 states right now across the country that do address property taxes for agritourism. And Kansas has done it twice in 2 different statutes that they've addressed. But in all of these cases, there is a state legislative pronouncement that we are going to treat agritourism the same as agriculture for property tax purposes. And I've highlighted for you a couple of different approaches. Those that are in white basically take the approach of, well, if there's ag tourism on that land that already qualifies as ag land for property tax purposes, then we're not going to let that agritourism disqualify that qualification. And that's how my state handles that. Agritourism on the property won't disqualify you from still receiving that differential property tax assessment. The ones in green kind of venture into that, well, wait a minute, let's look at how the ag tourism fits in with the overall ag operation. And you can see that they say in South Carolina, for instance, well, for property tax purposes, it's still agriculture as long as it's supplemental and incidental to a primary agricultural use. So we start to make that distinction in South Carolina as well as Kansas. In Kansas, if it's incidentally used for agritourism, then we will allow it to receive that property tax benefit. And then you have Florida, which has, I think, the most unique approach here, and I think really gets to this issue of why perhaps we should treat agritourism buildings differently and tax them differently. And that's what they're doing in Florida. They're saying, okay, agritourism doesn't deny that qualification for property tax assessment as agriculture for the land, but we're going to look at the building, and with the buildings, we're going to go ahead and assess the buildings at their just value and keep the land at the ag value. So 2 different things that go into the formula in Florida for property taxation of agritourism operations. The reason I say I think that makes sense is in my state, you will find, $1 million barns being built to have goat weddings, Jesse. High dollar buildings going on to these agritourism operations, and a lot of those local governments saying, wait a minute, why aren't we treating this as commercial? Why are we giving them this property tax benefit of being deemed agriculture? And so it's becoming an issue. Our legislature has not necessarily dealt with that. Let's pull the buildings out, let's pull the restaurants, all these really improved structures out and tax them differently. But I know that's something that many are talking about around the country. So what is the basis for doing that? Again, if we go back to the original intent, we want to protect agriculture, we want to protect agritourism, we want to allow that to thrive, but are we protecting it a bit too much, I think is what I'm hearing from some of those folks when it comes to property taxes. And so I just want to leave with a few, thank goodness for Stephanie here. I'm just going to close this. Just leave with a few critical questions that I think help us try to parse through these laws and decide what to do with them, whether it's the thing that we keep going back to, we keep trying to define agriculture, but maybe we need to step back for a moment and think about that big question I raised, what's the purpose of the law? But also, what is the relationship of this activity to agriculture? And I think that's where we start getting into that primary, accessory, incidental, core, peripheral. What is the relationship of the activity to agriculture? Can we try to approach our legal framework that way? And at some point, does this activity displace the agriculture and become something else. And I guess I think the something else in a lot of the situations I can think of would be, does it become a commercial use? Do we at some point say, okay, you're going to remain agriculture over until you reach this point, now you're commercial? And are we willing to take that step? I think in my state, our agricultural commodity groups, interest groups, Farm Bureau would probably be opposed to that. But that's the question that I'm hearing a lot of our regulators and our legislators and our local leaders raise is, this looks like commercial to me. It doesn't look like agriculture anymore. So what is that relationship to what we consider traditional production agriculture? And then second, I think scale begins to play a very important role in this. What is the scale of that activity? I know many farms in Ohio now that started out as traditional grain or livestock operations or a specialty crop operation, where now their agritourism revenue far exceeds their production revenue. And so the scale of what they're doing has just exploded. And when we start looking at that, does it now cross that line and become something else? But what do we base the scale on? Is it on revenue? Is it on number of events that they have? Is it the number of days that land is committed to agritourism versus production? I think there are a lot of questions when it comes to scale, but I think it's a question that if we can focus on, we might solve some of these problems. Okay, that's it for me.
All right, good morning. Thank you for letting me speak this morning. I'm going to bring it back down to the local level here in Maryland. I'm going to talk about specifically Queen Anne's County and how we've been moving forward with agritourism in the last couple years and the initiatives that we have moved forward with. So really, some of you have probably been to Queen Anne's County. Some of you probably maybe have never been. So I just want to give some overall characteristics of it. It's about 500 miles of waterfront, roughly a population of about 50,000. Our population is mostly dense there on the Kent Island area. Also, it's the gateway to the Eastern Shore as you drive across the Chesapeake Bay Bridge. And we have growth areas located, like I mentioned, on Kent Island, but also in our 8 municipalities. Our dominant land use is agriculture. So the lighter green you'll see on there on the screen is our agricultural land use. And our zoning is commensurate of that. So the dark green is our agricultural district. The lighter green is our countryside district. The countryside is specific to our critical area designation, but they are commensurate of each other and their uses. Okay, so what is agriculture in Queen Anne's County? Recently, through a study that we have done, which I'll talk about a little more, it was noted that there's 505 farms. The size of the farm has decreased, but the number obviously has increased. The largest commodity is grain. Mostly you'll see corn and soybeans in Queen Anne's County. The number of poultry farms have increased, and then as far as agritourism, the number of those agritourism farm-related uses have increased since 2017. And there's 2 wineries and 2 farm breweries. So I'm sorry for all the text, but otherwise I really can't show you what these definitions are, so I have the boring slides. Agriculture is basically defined in our code, but agritourism itself is broke up into mainly 2 separate definitions, agriculture, and you'll see in green, those are the uses that are mostly applicable to agritourism, so agriculture and agricultural support. So right now that is how our code is written. Like I said, I'll continue on about our study, but I just wanted to show that although the state does have their definition, each county's, like mentioned before, do have their own definitions. Some utilize the state definition, and others are like Queen Anne's and have it separate. Also, we have a definition for a winery and farm brewery, and then a farmer's market and a country store. So For some of you, I imagine most of you know what a comprehensive plan is, but I'm going to go back to 2022 when we adopted our comprehensive plan. Basically, a comprehensive plan is that 1,000-foot look at the county itself. It's a policy document. All counties in the state of Maryland, any municipalities are required to do so, and this is probably consistent across other states as well, but it looks at what the county's recommendations are for the future, trends, also how we hope to utilize and change our zoning code, as well as looking at the next 10 to 20 years. So how does this shape our future? So basically, like I said, it's a plan for the future. Includes recommendations, also goals. There's also indications about how our capital improvement projects might be kind of drawn out in the future, and also it includes a chart for our recommendations and strategies. But specific to agritourism and agriculture, this is where it really gets called out in our land use chapter and also our economic and tourism development chapter. So within our land use chapter, I know it's a lot of words, but if you look at the green underlined, that's basically the biggest portions of our comp plan that address agritourism in itself. But land use really just protects the existing land use where agritourism industries are located. Basically for growth management, we want to see all growth occur in our growth areas, not within the countryside and the rural areas. I know this one's a really busy one, but on the left-hand side, it talks about our priority preservation areas. In 2006, Maryland basically required all counties to designate a PPA. These are basically usually included in your comprehensive plan, but what that PPA does, it designates the counties to receive funding for preservation of farmland, but also it protects that farmland, like I mentioned, where these agritourism businesses are located. The point in the center there talks about how we need to look at the uses that are permitted in our agricultural and countryside zoning districts and basically support the increase of agritourism in those districts. On the right-hand side, it talks about the future of agritourism, how it's important, and how agricultural and agritourism can be supportive of the agricultural industry itself. So when we go to the economic and development tourism chapter, and I really want to make a point that in our most recent 2010 comp plan, the agritourism really wasn't mentioned. It was agriculture, but not agritourism. So this was one portion of our big update of our comprehensive plan. But in the economic development and tourism chapter, it does talk about how, although we have our commercial industries and our, all other maritime and industrial, we have agritourism and agriculture as well. And also that we need to retain those businesses and help with any newer businesses that come to the county. All right, so this one basically talks about how the county can grow as an economic sector because of agritourism, and also how we have the potential to expand that industry within the county. And this is really probably the most important piece out of all mentions of agritourism in our code, but basically it talks about how there's licensing and permitting and zoning requirements for agritourism, but also talks about the challenges and existing challenges that are within the county and also the state. You're looking at county regulations, you're looking at state regulations, how do they intermingle with each other, looking at health department regulations. But basically what it says is we need to update our code, make sure it's realistic for everyone. And this is a goal that's within the economic development chapter, explore opportunities for niche hospitality and tourism industries. And then number 2, under recommendations, develop and promote specifically agritourism and make sure that it's a working industry for those stakeholders. And this is even more specific. If you look at number 4 under recommendations, revise county code to incorporate provisions for agritourism and ecotourism. So what were those next steps? Queen Anne's County received a $75,000 grant from the Rural Maryland Economic Development Fund. This was awarded back in late 2023. We contracted with BAE Urban Economics in the spring of 2024. We are not completed this study at this point in time, but we have gotten to points that I can present on. So the scope of that study was really to look at the land use policy that the county has, look at the economic sector of it, have focus groups. So we spoke with industry leaders, we spoke with county boards and commissions, and also county staff, including regulators. We looked at case studies across the state. We looked at Frederick County, Carroll County, and Worcester County on the shore, and then basically drafted the recommendations which could potentially update our policy and land use regulations. So the final products we have are the economic land use and analysis, which is completed, and then we're drafting right now the policy document to follow. So what are those opportunities that have come out of that? Basically to hire someone to work within the county, basically to direct agritourism businesses and agribusiness itself, also for that person to work with the zoning and all other regulatory officials, but specifically for them to be housed in the Economic and Development Department. Plan for more events, expand the funding of the Micro Ag Grant Program, which is a program that the Rural Council gives to each county on the Upper Shore. Also to expand the reach of Annie's Project, which is a project that is through the Extension Office. It seems like there's been an increase in the number of participants in that, but also to, Annie's Project, sorry, I can't see this very well. But more specific to zoning, we really need to look at our definitions, kind of like I already indicated. Our agritourism uses are kind of spread out throughout our code. On the right-hand side there is Maryland's definition. I know it's a little hard to see, but really we need to include a definition of strictly just agritourism in our code. That way it aligns with the state code. And then for land use opportunities, we basically need to look at our agricultural definition and allow it to be just the bona fide agriculture in itself. Address agritourism and how there might be changes over time. Obviously, since agritourism has really come to light, it's changed over the years. We needed our definition to be kind of like a working definition that could move forward. We need to update our farm alcohol producers. We do not have a distillery use permitted in the county at this point in time, but also we need to be sure that our definitions and code are consistent with the state and not any more restrictive. Also, as we talked about all those weddings, we have a special events use. It's a conditional use right now, which is an approval by the Board of Appeals. There are some, with the conditional use, there's a limit on the number of days in which you can have a special event on the property, but with that comes along other restrictions. We need to look at, in order for the special events, to maybe look at a lesser of a use. Basically, for example, it'd be a permitted use if you only want to have 6 events, but if you want to have 20 or 25, it needs to be a conditional use. So what are those final steps? We need to complete that agritourism study and the policy document, fold those into our code, and as the state of Maryland requires, any updates to your zoning code need to be consistent with your comprehensive plan, which I kind of outlaid to show you how our code and our comprehensive plan has been updated to support agritourism. So that's all.
Wonderful. Thank you, everyone. All right, we have about 6 minutes for questions from the audience. We'll have plenty of time for questions. We got, all right.
Okay. I wonder if you can comment on the liability implications or other implications if the agritourism venture is also a nonprofit.
I can provide some context there. In most states, the requirement is that there be that commercial agricultural production taking place. So that sometimes does run up against a problem where we're looking at a nonprofit. But if we can get around that, then I think the liability protection would apply. if you look at those immunity statutes, in many cases, they'll say, you know, if you're agritourism, you have the immunity protection, but it's when you get into that definition of agritourism and there's a tie-in to commercial production that we see that problem occur. So I don't know if the situation you're envisioning would be one where there is not any commercial agricultural production taking place, but in a lot of states that would be a hindrance if there isn't, because you need that.
Commercial production was feeding all the profits back into the nonprofit for programming.
And I think that would be fine, but it's
Okay.
that, and Stephanie, I think in Maryland, you guys use the term bona fide. Some states use commercial ag production, some use working farm, but we need the origin of the agritourism activity to be kind of sitting on top of that bona fide production, commercial production. So if you have that, and then, you know, you can kind of argue over what commercial is. Do you have to have dollars involved, as Jesse had mentioned earlier or not? But even if you're making that money and feeding it into the nonprofit for program, I think that would be fine. There's nothing that would suggest that a nonprofit wouldn't have that immunity protection simply because they're a nonprofit. If they wouldn't have it, it would be because the land itself is not in ag production, commercial ag production, or bona fide production. Does that make sense?
Yes, thank you.
Nonprofits also have some type of liability protection as a nonprofit, but I think whether you fall under the Agritourism Liability Act or whether you're a nonprofit, whatever, the important thing is to have liability insurance that covers your activity, because courts don't like these liability acts, and I've seen producers and agritourism operators who say, yay, Agritourism Liability Act, no more liability insurance for me. Bad idea.
No, I just wanted to add, one of the things that I often get is are questions about nonprofit versus commercial, and really, nonprofit has nothing to do with whether or not you're commercial. Think of Goodwill stores. They're commercial, no doubt, but it's a nonprofit organization. So don't confuse the nonprofit status with the question of whether or not you're a commercial use.
Yeah, the commercial land use is really what we're referring to.
Right.
Good point.
We have one time for one more.
Which one are we pointing to, Meg?
Hi, I'm Kelly Dudek with Cultivate and Craft. We work with value-added agriculture. And I wanted to push a little bit on the agriculture versus commercial. I actually was working in Ohio 20 years ago when the Pregel Creamery case came up, which is the first time I really started to question the commercial versus agriculture. I think we're finding today that we're starting to say agriculture is commercial. We're trying to change people's mindsets a little bit about it, because there seems to be this, if you're turning a profit, you're no longer agriculture, you're commercial, and that's not the case. Our farmers need to turn a profit. So my question is, do you all see a danger in that narrative, or perhaps progress if we start to talk about it differently that way?
I want to start on that.
Yeah, I don't see a danger in it, except there is a group of people out there, I think, who believe that agriculture is a cute little bunny rabbit. And it's not, but you get a lot of preferential treatment because they think you're a cute little bunny rabbit. But yeah, I agree with you, and I don't think that should be a problem. If you don't make a profit, you're not going to be around very long.
Right, and when I raise the question of does it become a commercial use, I'm really thinking of that from a land use perspective. Should it be treated from a land use, a building code, a fire code perspective as a commercial use? But then when we go back to the farm itself, in many states there is a distinction between, are you in the business of farming, or are you just doing farming activities for your own consumption, or not because you're engaging in commerce? So I guess, to me, maybe that's the question. Is that operation trying to engage in commerce and in the business of farming and trying to make a living from farming? That's one thing. But when we look at the actual activities on that land, are they now starting to look less like production-oriented activities and more like commercial-type activities that bring people onto the property, that have people engaging in different things on the land? So I think as long as we can keep those two a little bit separate, that yes, we do need to raise the questions you're raising. Those are good, legitimate questions. Oh, there's one over there. Oh, I should have, I'm sorry.
Just as a comment to that, as one who works in local zoning matters, especially with a focus on agriculture, yes, a lot of people think agriculture is what I call the Mary Had a Little Lamb agriculture perception. But the other thing is that, yes, agriculture is a business, and we are in business to make money, and that's why we have agricultural operations. But there is a segment of the population who says, if I have commercially zoned land, and I have to pay commercially zoned land real estate taxes, and I need that zoning so I can do my business, if it's a winery or selling fabric or whatever, how come you farmers get a lower tax assessment and you get to do the same business on land that costs a fraction of what it costs me to buy a commercial piece of property? So that's where a lot of the conflict arises. Exactly. But that really wasn't my question. Are you going to address education on ag, or should I bring that up here? As in open air education, we're having some conflicts I'm in Hartford County, and we're having some conflicts on definitions and permitted uses and developing a plan or developing the code to address the changing face of education, where the specific use of the property is education, ag education, open air education. Comment?
Is that something?
Hi. Yes, so I think, are you talking about, a farm that's technically going to have classes for people to come in and to attend? Yeah. So I think in the last couple of years, that's something that has really rose to popularity. In Queen Anne's County right now, we look at that as agricultural support. Also, I think in the state definition, it does include education. So I would say yes, that it is something that should be included in agriculture.
Does it have to be on a bona fide farm then? I mean, do you have to have that commercial operation first, and then the education can come on that operation? Or no, they can be totally separate?
I believe they can be, there has to be a farm in order for them to have the agritourism use. Okay. It has to meet, in Queen Anne's County, it's about 5 acres or a little more. It's referenced on the tax article, basically is how it is.
And I'll just add, that's a great question for us to continue in our next 15 minutes. We have a networking break for everyone. So please join me in giving a round of applause to our panelists here for a great discussion.